I'm very concerned about children. If you watched my testimony in the last meeting, I'm very concerned about how a child can consent to provide any sort of data that could be used for a business interest moving forward. This is an open-ended question to anyone who wants to respond. Under socially beneficial purposes, how do we define a socially beneficial purpose? It's in the Act, 39.
The context of children.
Yes.
If we look at Section 39 and the
Yes.
definition of socially beneficial purposes, one of these purposes would be for disclosure to a healthcare institution, post-secondary education, or a public library. Certainly healthcare.
Thank you. I guess I'm most concerned about point 4, any other prescribed entity. What's a prescribed entity in the context of a socially beneficial purpose as it could relate to de-anonymized data from a child?
That would be a good question to the government because there's been no regulation.
Okay. Well, that sort of answers my question, is we don't know. And what I hear from you today is we talk about consent as well, and my concern is the consent of a child. We don't have a definitive age for a minor in this legislation. Do any of you want to comment on whether we need to define the age of a child? And should there be different tiers of consent related to a minor in this legislation? And again, it all goes back to my kid on an iPad when I'm sitting on an airplane or we're driving somewhere and he's in the back and he's clicking on certain things. I don't know where that information's going, and I get scared about that. And I'm fearful as a parent, and I know every committee member around here has similar concerns that I do. How can we address that in this legislation to make sure children are protected?
I'm happy to weigh in with some thoughts because it's something I've turned my mind to. So in the legislation, it refers to minors. And minors is defined by provincial law. Minors are 18 in Alberta and 18 in Quebec and 19 everywhere else. So there's a different line. One of the challenges that I think exists with children and privacy is that there really are not easily drawn bright lines that say under this particular magic age, you are completely under the control of your parents and you have no ability to consent in a valid way. Or over this age, you're magically endowed with those particular powers. As a parent of three young men now, you can tell that at different ages there are different levels of maturity, and it's difficult to determine. The way that it actually works in practice is difficult to operationalize. That you have to take into account the individual characteristics of the young person, and are they able to, Mr. Therrien talked about the requirements for knowledgeable, informed consent. Is the child capable of understanding what it is that they're consenting to, what those consequences are? And it's actually tied pretty similarly to consent to medical treatment, and so it's not completely isolated in its own little world. But
I'm going to pass it over to Mr. Kardash just because that was a great point, Mr. Kardash.
The statute expressly sets out that minors' data is sensitive information. It's expressly contemplated in that.
Yes.
And by doing so, what ends up happening is that many of the other provisions in the statute have to look at the treatment of sensitive information. So, for instance, when you're dealing with safeguarding is appropriate, implemented, it's appropriate to the sensitivity. When you consider different requirements,
Thank
like
you.
even
So
consent,
would the provisions related to sensitive information outlined in Clause 12 override, say, Clause 38 of the bill, as it relates to the use of information for literary purposes, for example, in the context of children?
So I think once you take data and there's more sensitivity to it, there'll be a holistic set of provisions in the Act that will be applied. Even currently, the case right now with Section 5.3 in the statute, and it's amended now, it's even more involved. Organizations are only allowed to collect, use, and disclose personal information that a reasonable person would consider appropriate. Now, that might seem broad, but that's privacy protective in nature, because the more sensitive the data, that will impact your statutory analysis of what a reasonable person would consider appropriate in the circumstances.
Thank you. Do we need to define a child in this legislation?
I don't think so. Under the age of minors under the age of 13, they wouldn't have the capacity to consent, et cetera. That would be protected. Data would be protected otherwise. There is an idea about specifying under the age of 18. I think it works right now. I don't think you have to do it. The key thing in the statute, which goes to the heart of your concern, I think the concern of everyone in the room, certainly myself, is the protection of minors, very important, but there's express contemplation already in the statutory framework that it is sensitive data, and that has a flow-through impact, and it would be treated well, certainly from a statutory interpretation perspective.
Do you believe we need to do more to amend Section 12 to be 100% sure that the rights of children, when we define a fundamental right to privacy, are given the attention it deserves? Mr. Terrien.
The Minister Champagne has tabled amendments to the preamble and to Section 12 that would provide greater protection to children. Again, that is a step in the right direction. But I'm concerned that the terminology used may be too limitative, and that is why I have recommended in the text I have provided with you that Section 12 be amended to refer to the concept of the best interest of the child.
Best interest
That
of the
concept has to be interpreted contextually. It is not limited, although again, the language proposed is a step in the right direction, but it may be too limitative, and I think the concept of best interest of the child would provide fuller protection.
Mr. Terrien, I'd just like to follow up on MP Vis's questions initially, just from the start, on the issue of minor. The only place in the bill that minor is mentioned is in the interpretation section at the beginning. It doesn't define a minor, and I think a lot of us are in agreement this bill should define an age of the minor. But it also says that this act, the personal information of minors, is considered to be sensitive information. But for the life of me, when I look through this act, I don't see any definition of what sensitive information is.
The concept of sensitive information is currently undefined under the current law and would be under the proposed law, which normally leads to what is called a contextual application of what is sensitive. So what kind of information is at play? Is it financial? Does it concern children? Does it concern health? That would be generally sensitive information under interpretation, but there's no definition in the law itself. Is it a flaw that there's no definition? At the end of the day, the definition will always be contextual. I think it is possible, though, to have a definition which would be non-exhaustive, which would refer to certain factors, financial, health, children, etc., a non-exhaustive list of factors that would define this is normally sensitive information, leaving an out clause, a residual clause, for what is not defined. I think that would be an improvement.
As a person who spent most of my career as a marketer, I love data, and I would go to the edge as much as possible that I was aware of and what I could do with that data. But I tell you, this bill and those aspects would make me nervous because I just don't see as a marketer any guidelines that help me figure that out, and I suspect most marketers would push the envelope as they do, and that may end up in trouble for their company. So I appreciate that there should be more definition.